everyone. I am Rocco Limangelli from Sant'Anna School of Advanced Studies. Welcome to this Regulate lecture on the Data Governance Act and the Data Act. If you haven't already, there is an introduction on the EU data strategy, which gives you an overview of the main objectives of the EU in regards to data, and an overview of these two pieces of legislation, the Data Governance Act and the Data Act. So let's jump into it. The Data Governance Act, it's actually coming into force in September 2023. So let's have a look at what is the main scope. In today's data-driven world, the Digital Governance Act plays a pivotal role in guiding the appropriate handling of data, particularly when it comes to data sharing and reuse. But what specifically is within the scope of the Data Governance Act? Well, the Data Governance Act outlines principles and set up governance frameworks for data that falls outside the jurisdiction of another important legislation, which is the Open Data Directive. So what data falls outside the scope of the Open Data Directive? Well, there are certain categories of public sector data that do not come under the purview of the Open Data Directive. This includes sensitive data, defined sensitive under the GDPR. So if you're not familiar with sensitive data, I would strongly suggest you have a look at the lecture on the General Data Protection Regulation and data protection laws that we have within this series. And data that is protected by intellectual property rights, or under commercial confidentiality restriction, so proprietary data. This means that the Data Governance Act comes into play when dealing with sensitive or proprietary data. For instance, if a public sector body holds data that is commercially confidential or data that is protected under intellectual property laws, the Data Governance Act would govern the use, sharing, and reuse of this data. In essence, the Data Governance Act sets up a framework for assuring that sensitive and proprietary data are appropriately managed, balancing both the need for privacy and confidentiality with the potential for valuable insight and innovation through the sharing and reuse of this data. So let's look at who the Data Governance Act applies to. And we got here a list of the parties that would be more involved within the Data Governance Act, being public sector bodies, data intermediaries, and recognized data altruism organizations. So it does apply to public sector bodies. This could be government departments, local authorities, and various set of government institutions. However, state-owned businesses wouldn't fall within the scope. The second category involves data intermediaries, and this is actually quite a novel concept within the Data Governance Act. These are neutral third parties that play a critical role in the data flow within the Union by brokering the transfer of data from the data source, which could be individuals or companies, and to the data users, which are going to then reuse the data for various purposes. In the intricate web of data exchange, intermediaries actually facilitate connections, ensure compliance, and promote effective data utilization, and do play an extremely important role in this novel approach to the data-driven economy. Lastly, another very interesting concept, quite novel, it's data altruism. In fact, the Act applies to entities referred to as recognized data altruism organizations. These are quite unique entities made up of individuals or companies who voluntarily want to share their data and make it available free of charge with the intention to contributing to the public good. Their operation is under the control and the regulation of the Data Governance Act, which helps ensure that the altruistic data sharing operates within regulated and safe boundaries. So let's have a more in-depth look at data intermediaries. Well, data intermediaries play a pivotal role in the digital landscape, facilitating, as I mentioned, the smooth flow of data between various parties. However, there are crucial regulation in place to ensure that their operation promote a fair and open data ecosystem. So, firstly, data intermediaries must remain neutral. This means that they cannot use their own, to their own benefit the data that they're actually brokering. Companies that want to do that and want to be data intermediaries as well, they need to set up a separate structure as a data intermediary. And again, that structure needs to be neutral from their main business. Their role is in fact to serve as a conduit, transferring data from one point to another without any personal gain or manipulation of the data. The neutrality is essential in maintaining trust within the system. Moreover, the procedure through which data users access the service of data intermediaries must adhere to three core principles, which we've seen through European legislation in and out, which are fairness, transparency, and non-discrimination. Fairness means that all data users should have equal opportunity to access and utilize intermediary services. Transparency refers to the clear and understandable rules and processes involved in the access of this data and the use of the intermediary services. Every aspect of the operation of an intermediary must be fully transparent, openly communicated to data users. And finally, non-discrimination signifies that no data user should be treated differently based on any particular characteristics they have or criteria whatsoever. All users should have and should be granted equal access to the same opportunities when interacting with data intermediaries. And diving a bit deeper on the requirements of an obligation of data intermediaries. Firstly, they're required to actually register with a national regulatory body and will appear on a public register. This measure, in fact, is trying to achieve a high degree of accountability, promoting transparency and trust in the system. Secondly, to avoid conflict of interest, data intermediaries must not provide any other services. As I mentioned before, they need to be neutral. They need to do only that. They can only carry out data intermediaries services and provide that kind of services. They must be separate legal entities from parts of a business that seek to exploit the data, as I mentioned. And this separation is in fact crucial in maintaining the intermediary neutrality. Finally, data intermediaries must always act in the best interest of the data subjects. They must provide data subjects with the necessary tools to give or withdraw consent where applicable. And this obligation places rights of data subject at the forefront, as freedoms are valued quite a lot in the European Union. They are usually placed at the forefront of any legislation. And this obviously is going to grant and ensure the data subjects' control over their data, the respect of their privacy and autonomy. And just to give you an example of a data intermediary already existing, the Data Intelligence Hub from Deutsche Telekom. Hopefully that's the right way to pronounce it. So the Data Intelligence Hub is essentially a data marketplace, a platform where companies can securely manage, provide, and monetize high quality information. So this could be a variety of data, such as production data, which can be used to optimize industrial processes and enhance their efficiency. So imagine you are a manufacturing company. With Data Intelligence Hub, you could securely store and manage your production data, and at the same time, you could offer the same data to other businesses, maybe in a view to partner up with other businesses as well, and to monetize as well on your data. You could offer your data to consultants who could utilize it to analyze trends, predict demands, or develop new innovations, which again is going to create more value for the data you've created. Is going to give you more information on your data, and possibly while you're monetizing on the data, you can be able to enhance your production and the way you're doing things as well. In doing so, not only, in fact, do you monetize on your data, but you also contribute to the wider optimization of the industry process, your industry process, and the industry more in general. Let's now jump into data altruism. So, in this increasingly interconnected world, sharing data, it's not just a matter of business or innovation, but it can also be, we can say, an act of altruism, in fact. And the EU calls this data altruism. Data altruism refers to the practice where individuals or companies voluntarily consent to the use and provide their data. This could involve contributing to research, supporting non-profit initiatives, or aiding public policy development. However, this does not mean that data is simply shared by these people or companies in a reckless way. In fact, recognized data altruism organizations are at the forefront of this practice. These organizations need to meet specific criteria. They must be not-for-profit organization, legally independent, and structurally separate entities. This ensures that data shared for altruistic purposes is used responsibly and solely for the intended altruistic purpose. And similar to data intermediaries, the data altruism or recognized data altruism organization need to be in fact be recognized by competent regulatory bodies, and a list would be public and published. In essence, data altruism promotes the principle of shared benefit, of reusing and sharing data for societal progress. In fact, data altruism organizations have a unique and crucial role in the data landscape. They are responsible not only for stewardship of shared data, but also for the protection of the right of the data subjects. And primarily, this organization are obliged to safeguard data subjects' rights. This means ensuring the secure handling and storing of personal data. Moreover, data subjects must be informed in advance of the altruistic purposes that their data are going to be used for. And transparency here is key. The data needs to be used only for that specific altruistic purposes as communicated to data subjects. Additionally, data altruism organizations are mandated to provide tools for individuals to easily withdraw their consent at any time. This again empowers data subjects with control over their data, over their rights, and over the rights to privacy, and ensures autonomy. In essence, while the goal of data altruism organization is to use data for altruistic purposes, they must do so with the utmost regard to the rights and consent of data subjects, establish trust, and fostering a responsible data sharing culture. And here again, I think another example is important to give examples to better understand how this organization will be working once we've got more of them around. And Smart Citizen, it's a platform that stands as a shining example of how data altruism can contribute to societal progress and address real-world problems. Through these platforms, in fact, citizens are given the opportunity to share data collected through sensors in their home. And these sensors can measure, various kind of things from the from environmental factors such as noise level and pollution to consumption of electricity, energy, and so on and so forth. This might sound like a no-brainer. Like, why haven't we done this previously? And the reason for it is because there was no infrastructure to do this previously. And sharing this kind of data could have profound and important implications to the society as a whole. Imagine having a sensor in your arm that consistently measures noise levels or the quality of the air. The data from your sensor combined with the data from thousands of sensors of other arms can provide accurate and detailed maps, for example, of noise and air quality across different regions. This aggregated data then becomes an invaluable resource for researchers, engineers, and whoever else who are trying to understand this issue at a more granular level or building more efficient homes. Similarly, governments can use this data to develop target solutions to issues such as low energy rating in homes, which is a huge problem, for example, in Italy, with approximately 87% of houses having a E as energy rating. In relation to international transfers, I mean, when you talk about data, you always need to talk about international transfer. We do that. We've done that with the GDPR. We're doing that with the Data Governance Act. We'll do that with the Data Act. So international transfer data outside the Union are subject to stringent regulations, and it's very important to understand them. They are generally not allowed. There are only two exceptions to this. So if an international agreement permits it, or if an international judgment directed it, subject to minimum requirements, which can pertain to, for example, the adequacy of data protection measures and technical measures, safety measures in the receiving country. Furthermore, the Data Governance Act is setting up the European Data Innovation Board. The primary role of this board is to facilitate the sharing of best practices across the European Union, with particular focus on several key areas. This will include data intermediaries, data altruism, and the use of public data that cannot be made available as open data. It will also prioritize the establishment of cross-sector interoperability standards, ensuring smoother data flow and integration across different industries and businesses. Moreover, the European Data Innovation Board will have a vital role in maintaining the integrity of international data transfer from the European Union. In fact, we expect that, and the European Data Innovation Board has the power to make adequacy decisions, such as the ones that we've seen with the General Data Protection Regulation. Take as an example the United Kingdom and Brexit. What they've done is they've become a third country under the eyes of the General Data Protection Regulation. However, an adequacy decision was made on the UK because they basically have the same, they entrenched the GDPR into national law. They were made as if they were part of the European Union through the adequacy decision. Another thing that the European Data Innovation Board is likely to develop an issue is standard clauses for international transfer. So it's going to be another way to allow international transfer to through standard clauses, as again we can see currently with the GDPR. We do have that option. Let's now have a look at the Data Act, the other piece of legislation within the EU data strategy. So what is the main scope of the Data Act? Well, the Act serves as a crucial piece of legislation in this modern digital economy, as its main focus is facilitating the use of product-generated data by third parties. In essence, the Data Act aims to provide a fair and level playing field, enabling third parties to access and leverage the valuable data generated every day in the European Union by various products. In addition, the Data Act prioritizes data interoperability. It emphasizes the ability of different data systems, devices, and applications to work together, exchanging and mutually interpreting data. This interoperability is a key driver of innovation fostering an environment where new applications and services can be developed seamlessly and efficiently. So the main aim of this is to actually empower users, enabling them to seamlessly move their data from one cloud service provider to another without obstacles such as charges and so on and so forth. Therefore, the main scope of the Data Act spans from facilitating third-party use of product data to promoting data interoperability and enabling smoother transitions between cloud service providers. So, as we did before for the Data Governance Act, let's have a look at who it applies to. So, firstly, it applies to manufacturers, manufacturers of products and suppliers of related services placed on the EU market. So whether you are a producer of IoT devices or a provider of digital services, if your products or services are available within the EU, you will have obligations under the Data Act. Next, it involves the data holders, which are the ones that make data available to recipients in the EU, and those data recipients. It also includes EU public sector bodies in instances where there is an exceptional need. And think about public emergencies such as the COVID-19 pandemic. Then data processing services. So providers of data processing services operating within the EU also come under the scope of the Data Act. If you offer data processing service to consumers in the EU and you're not based in the EU, then you're required to adhere to the rules of the Data Act regardless. And lastly, the Data Act applies to operators within data spaces, which we've discussed briefly previously as well, and certain vendors who are using and deploying smart contracts within the EU. If you operate within this rapidly expanding array of data spaces, then you will have stringent obligations. And if you use smart contracts as well, you will have obligations on the design of the contracts, but we will look at that in more detail in a second. Let's look at what the obligation under the Data Act are. But before doing that, we need to be reminded that the Data Act operates without prejudice to current data protection laws, such as the General Data Protection Regulation. Therefore, when applying the Data Act, you must always first look at whether the GDPR gives indication on what you should do with data before then being able to move on to the Data Act. So it is a job that requires you balancing and analysis of both legislation at the same time. When dealing with data, you must always remember to look at the GDPR and whether it's applicable to the data you're dealing with. But let's now look at some of the obligation under the Data Act, and let's start with B2C and B2B IoT data access. And so basically, data holders such as manufacturers, service providers who initially control the data are required to give users either the owner or renter of the product readily available free access to data generated from the product use. So before the product is even purchased, the data holder must provide comprehensive information to the user. The information should cover the purpose of the data generated, the methods of data generation, how to access the data, and the terms of access, as well as details on the data holder's identity, means of communication, and rights of the user. Furthermore, data users have the right to directly share this data through data intermediaries or data altruist organization. And this can be done for either commercial, through data intermediaries possibly, or non-commercial purposes, such as aftermarket and value-added service as well. So possibly you've got a product you want to repair, you are no longer bound to get that product repaired from the manufacturer. You can ask the manufacturer all the data and go to a third party, maybe for a better service or cheaper price. However, it is important to note that users are strictly prohibited from using the data to develop a product that competes with the product that has originated and generated the data. Moreover, data holders may only share data for fulfilling their contractual obligation to the user and must adhere to certain obligations regarding the use of data. Recipients of the data are also subject to various obligations around the use of the received data, and the Data Act does stipulate specific requirements on the contractual terms governing data sharing between enterprises, ensuring transparency and fairness in the process. Another obligation is in B2G data access, which is business to government data access. And under the regulation, data holders are obliged to make data available to certain public sector bodies and EU institutions. This, however, applies only where there is an exceptional need demonstrated, such as, again, a public emergency, such as in a pandemic. Data holders may, depending on the circumstances, be required to provide this data free of charge, or they may have the option to impose a charge depending on the situation. It's noteworthy that public sector body in receipt of this data can choose and are able to share it further, potentially with, for example, other public bodies or national statistic institutes, Eurostats, or individual and organization conducting scientific research. However, this sharing must be done with in a fully transparent manner, meaning that the data holder must be notified of any intention of sharing this data, and the data holder has the right to object on further sharing of this data. Then cloud services. As we mentioned, it's quite a big topic within the Data Act. And as per the new regulation, cloud providers are now subject to certain obligation to facilitate the switching process between one cloud service to another cloud service. First and foremost, this will include the right for the customer to terminate services on a 2 months notice, and that's the idea. It's 2 months at the moment. In the final text, this time period, and when the Data Act comes into force, it might change. Furthermore, cloud providers must aid in the porting of data when a customer decides to switch. So it's important to note that this transition should be completed within 3 months as provided by the current text of the Data Act. Also, there is a provision regarding switching charges. So the cloud service providers will no longer be able to charge any amount for switching from one service provider to another. These rights and obligations are not optional. They're provided within the Data Act. And they must be explicitly included in the terms of service by the cloud service providers. Let's quickly look as well at data interoperability, which is another important concept within Data Act. Data interoperability plays a crucial role in the digital landscape, and the Data Act addresses truly. It does this address data interoperability in relation to data spaces set up as part of the EU data strategy. Just to clarify, when we refer to data spaces, we mentioned this already, we're talking about the 9 European data spaces that are currently being set up. By no means there are going to be 9 data spaces. These are the ones that are currently being identified. They might increase depending on new rising sectors or industries. The regulation stipulates that operators of these data spaces must provide APIs, application programming interfaces, with continuous, real-time, and machine-readable access to data. Further, operators are also required to equip data recipients with the means to enable smart contracts to interoperate within their service or activities. This implies that operators play a pivotal role in enabling seamless interaction and data exchange across different platforms. However, speaking of smart contracts, actually the Data Act does give minimum requirements to the drafting or development, if you would allow me, of smart contracts. And the goal here is in fact to create a level playing field for all participants to ensure secure and controlled flow of data and maintain the integrity of trade secrets even in a highly interconnected digital economy. And just to conclude, what I like to call a kind of bonus, which is there. It's going to be used possibly in very sporadic instances. It's non-EU government access of non-personal data. So the Data Act extends its provision to incorporate safeguards related to this specific kind of situation where non-EU government would be trying to access non-personal data held within the European Union. The providers are in fact obliged to put in place measures that are reminiscent of the GDPR, such as encryption, and the aim is in fact to prevent non-EU government entities from accessing non-personal data held within the Union. Conflicts, in fact, may arise. For example, if non-EU government access non-personal data, this could jeopardize national security or trade secrets in some situations, or if it would infringe upon EU individuals' fundamental rights. It is worth noting that any access by non-EU government must be grounded on a legitimate basis, such as international agreements like a mutual assistance agreement or treaty. Through these measures, the Act seeks to ensure a higher level of data security, uphold EU legal standards, and protect the right of EU citizens and entities that face in the face of possible non-EU government access. And to finalize, possibly we would need to look at the consequences as well of non-compliance with the Data Act. In terms of consequences of non-compliance, nothing new in terms of fine was introduced by the Data Act. So the fines under existing laws such as the GDPR still stand and would apply. However, one thing would be that non-compliance with the Data Act would result in the clauses within a commercial contract or a contract in general that are non-compliant with the provision of the Data Act to become unenforceable. So to conclude, it is essential that we emphasize the need to prepare for the significant impact of the Data Governance Act and the Data Act. These two pieces of legislation are changing the landscape of data management and will have direct implications for many businesses, particularly those operating within the digital realm or dealing in some form within the internet or Internet of Things, or interconnected, or products interconnected with Internet of Things. The implication of this regulation should not be understated. As businesses, it is crucial to understand that both the Data Governance Act and the Data Act are directly applicable regulations of the European Union with their own specific compliance requirement and enforcement mechanisms. This means that, opposed to directives, they will be directly applicable, and as soon as they come into force, they will have effect. Failure to comply can lead to serious legal and reputational consequences, so it is worth taking the time to fully understand this regulation, evaluate how they possibly can impact your business and operations, and then implement the necessary steps to ensure full compliance as soon as possible, so that you are geared once the Data Acts come into force, as the Data Governance Act already is into force, will be into force in September, or already is, again, depending on when you are looking at this video. So thank you very much. I hope you enjoyed this lecture. I am available if you got any further question. Here is on this slide my email address, and good luck with everything. Thank you.